Okay, let's unpack this. Imagine a country working really hard to heal from a deeply divided past, where some laws still clung, to very discriminatory ideas. Today, we're taking a deep dive into a landmark legal case from South Africa. It radically reshaped who inherits property when someone passes away, particularly for a segment of the population previously governed by, well, frankly, outdated, racially biased laws. It's really a story of how the highest court tackled centuries of discrimination head-on, delivering a kind of aha moment for equality and dignity.
Yeah, and what's fascinating here is how these cases, which actually started as three separate legal challenges, they sort of converged. And they forced a fundamental rethinking of personal law. The law governing family matters. This isn't just about dry legal technicalities. It's about real people, real families, and the profound impact law has on their lives, especially for women and children who are often just overlooked.
Right. So our mission today is to break down this complex legal battle, Bhe v. Magistrate, Khayelitsha, and the related cases in an engaging way. We'll look at the key legal issues, the arguments presented, how the court reasoned its way to this really big decision, and the lasting significance of this ruling for South Africa's journey towards, well, true equality.
Yeah.
So to understand what was at stake, we really need to go back to the existing legal landscape. It sounds complicated.
It was. South Africa basically had a parallel system for intestate succession. That's what happens to your property if you die without a will. On one side, you had the Intestate Succession Act of 1987, which applied broadly, sort of the modern standard.
Okay.
But then for a specific group of people, there was the Black Administration Act of 1927, a much older and, profoundly problematic piece of legislation.
From 1927. Wow.
Precisely. The Black Administration Act, specifically Section 23, along with its regulations, created this separate, often discriminatory system. And it was exclusively for Africans, that was the term used in the judgment, reflecting the historical context. It purported to give effect to customary law of succession, but what it really did was codify and in many ways distort it, sort of froze it in place.
And here's where it gets really interesting. Central to that customary law system, as it was applied by the Act, was this principle of male primogeniture. So, in broad strokes, what did that actually mean for families on the ground?
If we connect this to the bigger picture, male primogeniture meant that generally only males related to the deceased through the male line could inherit property. So women, wives, daughters, and even younger sons were often excluded. This was the fundamental issue challenged in these cases.
So they were challenging two things.
Exactly. The constitutional validity of Section 23 of the Black Administration Act itself, and the constitutional validity of this principle of male primogeniture as it was being applied within customary law succession.
Right. This deep dive really centers around those three cases, heard together by the Constitutional Court. Let's start with the Bhe case. Who were the key players and what was their situation?
Okay, the Bhe case involved Mrs. Bhe and her two minor daughters, Nonkululeko and Annalisa. Their father, Mrs. Bhe's partner, died without leaving a will. Under Section 23 and the regulations, the local magistrate appointed the deceased's own father, Mr. Magallambane, as the sole heir and representative of the estate.
The grandfather, even though the man had children.
Yes. Mr. Magallambane lived in a different province, mind you, but under this rule, he was the heir. The minor children, his own granddaughters, were completely excluded from inheriting their father's property.
And the practical consequence of this rule sounds like it was potentially dire, right?
Absolutely devastating. Mr. Magallambane apparently intended to sell the property of the family home, which would have left Mrs. Bhe and the children homeless. So the applicants challenged this. The Cape High Court actually declared key parts of Section 23 and its regulations unconstitutional.
Oh, okay. So the High Court already saw the problem.
It did. It has said the Intestate Succession Act should apply instead. And crucially, it declared the minor daughters as the sole heirs, a major step.
Okay, then there's the Shebe case. How did that play out? Was it similar?
Similar principle, different family relationship. Charlotte Shebe's brother died without a will or any children. According to the male primogeniture rule, his closest male relatives were considered the heirs, in this case his male cousins.
Not his sister.
Nope. Mrs. Shebe, his sister, was excluded purely based on her gender. The magistrate appointed one of the cousins. And then there were complaints that the cousin was misappropriating the estate funds, so Miss Shebe challenged it, and the Pretoria High Court delivered a similar ruling to the Bhe case, declaring Miss Shebe the sole heir.
Right, so two high courts reaching similar conclusions. And finally, the South African Human Rights Commission and the Women's Legal Center Trust jumped into the fray. What did they add to the argument?
They sought direct access to the Constitutional Court, which kind of broadened the scope significantly. Their argument wasn't just about specific subsections being bad. They argued that the entirety of Section 23 of the Act was unconstitutional, root and branch.
Which raises an important question. Why was direct access granted? Usually cases work their way up.
That's a good point. The court recognized the immense impact these provisions were having on vulnerable groups, particularly African women and children. It felt it was desirable to bring clarity and certainty as quickly as possible. The judgment actually says this application, quote, helpfully broadened the scope of the constitutional investigation, given the need to deal effectively with the unwelcome consequences of the act in the shortest possible time. Basically, it was time to deal with this properly once and for all.
So what specific parts of South Africa's post-apartheid constitution did these outdated laws clash with? What were the core constitutional arguments?
Primarily, it came down to the rights to human dignity, equality, and the specific rights of children. These were central to the challenge. Let's start with human dignity, which is protected by Section 10 of the Constitution.
Okay, let's unpack this a bit. How does a succession law, something about who gets property, violate someone's dignity?
Well, the court has consistently emphasized that dignity acknowledges the inherent value and worth of all individuals. It's fundamental. The rule of primogeniture, by excluding women from inheriting, essentially sent a message that they were not fit or competent to own and administer property. It subjected them, as the court put it, to a status of perpetual minority simply because of their sex and gender.
Like they were lesser beings.
Exactly. And this was seen as a clear affront to their dignity, especially given South Africa's past, where, as the judgment notes, human dignity for Black South Africans was routinely and cruelly denied. This rule echoed that past discrimination.
Yeah, that makes sense. And the right to equality, Section 9, seems like an obvious point of conflict here, too.
Oh, absolutely. The court paid immense words. It called Section 23 a racist provision, fundamentally incompatible with the Constitution, and a relic of our racist and painful past. It discriminated blatantly on grounds of race, color, and ethnic origin. The choice of which succession law applied was based purely on skin color, forcing this system onto Africans regardless of their actual lives or wishes.
And you mentioned that demeaning reference in the regulations, distributing estates as if the deceased had been a European. That really just highlights the overt racism, doesn't it?
It really does. And beyond race, the equality challenge extended to gender and birth. The exclusion of women from heirship was a clear violation of gender equality. And the term birth in the Constitution's Equality Clause, Section 9(3), was interpreted by the court to include discrimination against extramarital children, children whose parents weren't married.
Ah, so children born outside of marriage were also disadvantaged by this.
Yes. Historically, these children faced social stigma and legal disadvantages, particularly under common law. While customary law was sometimes seen as more accommodative, the way Section 23 applied it still often reduced their inheritance rights compared to legitimate children, especially for male extramarital children. So it was discrimination based on the circumstances of their birth.
And what about the rights of children specifically? Section 28 of the Constitution.
Right. Section 28 states that a child's best interests are of paramount importance in every matter concerning the child. Denying female children the ability to inherit altogether and significantly curtailing the rights of male extramarital children was found to be a direct violation of their rights under Section 28. It was also seen as another form of unfair discrimination, again, on the ground of birth and also gender for the girls.
Okay, so with these powerful constitutional arguments laid out, dignity, equality based on race, gender, birth, and children's rights, how did the Constitutional Court then reason its way to a decision?
The court, quite decisively, found Section 23 of the Black Administration Act to be unconstitutional and invalid. Full stop. It said its destructive purpose and effect meant it could not be justified in any open and democratic society. The inherent racism, plus the way it sort of ossified customary law, preventing it from evolving naturally, it was simply intolerable under the new Constitution.
Right, so striking down the statute was clear, but then came the central issue of the male primogeniture rule within customary law itself. How did the court approach that? That seems more complex.
It was definitely more nuanced. And this raises an important question the court grappled with. What is the true nature of customary law? The court acknowledged that in its traditional setting, customary law of succession wasn't just about dividing up property. It was deeply connected to preserving the family unit, the community. It involved the transfer of status and responsibilities. The heir wasn't just getting assets, they were meant to step into the shoes of the family head, using the family property to support all the dependents.
Ah, so it had a social function, not just economic. But that traditional context had changed dramatically by the time of this case, hadn't it?
Precisely. That was a key part of the court's reasoning. It noted that modern life, especially in urban areas, meant families often no longer operated purely along those traditional lines. Nuclear families are common. And crucially, the heir often acquired the estate without necessarily assuming those traditional responsibilities of supporting all the dependents. The link was broken. The official customary law, the version written down in textbooks and applied rigidly by officials, had failed to adapt to these changing social conditions. Unlike living customary law, which is how communities actually adapt practices over time.
So the justification for excluding women and extramarital children, which might have been tied to those older traditional roles and responsibilities, that justification just didn't hold up anymore.
Correct. The court found that the rule of primogeniture, at least in how it was being applied to inheritance by the state, had been distorted. It now emphasizes its patriarchal features and minimizes its communitarian ones. It became primarily about male control, not community support. Therefore, it was a clear violation of women's equality and dignity, subjecting them to that status of perpetual minority. And similarly, the rule unfairly discriminated against all female children and extramarital children, violating their constitutional rights.
And this meant that previous court decisions, like the Mthembu case you mentioned, which had kind of upheld this rule, they were effectively overturned.
Yes, the court was very explicit. It stated that any finding in the earlier Mthembu case that was at odds with this new judgment cannot stand. It signaled a very clear break from past judicial interpretations that had allowed these discriminatory practices to continue, a real turning point.
Okay, so once you've struck down these deeply entrenched laws and overturned precedent, you're potentially left with a legal vacuum, right? What was the court's approach to crafting a new path forward for succession? How do you fill that gap?
That was a huge challenge. The court had to craft a remedy. Simply striking down the laws wasn't enough, because that would create chaos and uncertainty for the huge number of people whose lives were still governed by customary law principles. But they also couldn't just suspend the declaration of invalidity, because that would mean prolonging the injustice for vulnerable groups like women and children.
And trying to develop the customary law itself, the living law, seemed too complex at that point.
Exactly. The idea of developing living customary law was discussed, but the court felt it didn't have enough evidence before it to confidently determine the true content of what people were actually practicing across the whole country. It varies a lot. Plus, developing it case by case would be incredibly slow and likely lead to lots of inconsistencies. So a more direct, uniform solution was needed, at least in the interim.
So what did they decide was the most just and equitable solution right then and there?
They opted to apply the existing Intestate Succession Act, the one used for other population groups, but, and this is key, with crucial modifications. The big advantage was that this act would immediately ensure that extramarital children, women survivors in monogamous unions, and unmarried women wouldn't face discrimination in inheritance. It provided a ready-made framework for equality. However, a major hurdle remained. How do you make this act, which assumes monogamy, work for polygynous unions, which are recognized under customary law?
Right, that's fascinating. How did they adapt a law built for one kind of family structure to fit another, very different one? That must have required some creative thinking.
It really did. To address polygynous unions, the court's order included very specific provisions. It said, okay, when calculating a child's share of the inheritance, you have to take into account the number of all surviving spouses, not just one. Then each surviving spouse would inherit either a child's share or a minimum monetary amount set by law, currently are $250,000, whichever amount is greater.
Okay, so ensuring each wife got a decent minimum share?
Yes, trying to ensure fairness. And if the estate wasn't large enough to give each spouse that minimum amount, then all the surviving spouses would share whatever was available equally amongst themselves. It really demonstrates the court's commitment to protecting the interests of all surviving spouses in these unions without actually making a pronouncement on the constitutional validity of polygynous marriages themselves. That was a separate issue for another day.
Clever. And the timing of this change, how far back did it apply? Did it help people whose relatives died years ago?
This is also really important. The court made the declaration of invalidity retrospective. It applied back to 27 April 1994.
Ah, the date the interim constitution came into force.
Exactly. That date is hugely significant in South Africa. It means that justice would extend to those who died after the new constitutional order began, even before the final constitution was adopted in 1996. However, there was a safeguard. To prevent causing new kinds of hardship or undoing things unfairly, the retrospectivity does not apply to any estate where the property had already been formally transferred to an heir, provided that heir was genuinely unaware that the law was being challenged at the time. It protects completed good faith transactions.
That seems like a fair balance, and it sounds like even with applying the Intestate Succession Act, the court still left room for families to make their own arrangements.
Absolutely. The order doesn't mean the Intestate Succession Act becomes this rigid, unbending rule that ignores family wishes. Families can still reach agreements among themselves on how the estate should be divided, maybe following certain traditions if they choose, provided, and this is crucial, those agreements are genuine, they are consistent with constitutional principles, so no unfair discrimination, and they do not prejudice the rights of any vulnerable family members, especially minor children. And importantly, officials like magistrates and the Master of the High Court now have a special duty to scrutinize these agreements to make sure they're actually fair.
So wrapping this up, what does this all mean? What's the lasting impact of this deep dive for you, the listener, and for South African society?
Well, if we connect it back to the bigger picture, the judgment fundamentally dismantled a legal relic of apartheid. It was a really powerful blow against racial, gender, and birth discrimination in the law of succession. A major practical change is that the Master of the High Court, who previously had no jurisdiction over these estates because they fell under the Black Administration Act, well, the Master now administers all new intestate deceased estates that were formerly governed by Section 23. These estates are now dealt with under the Standard Administration of Estates Act. So it's a huge shift towards legal uniformity and equality before the law for everyone.
It really sounds like a move towards a more truly egalitarian society, putting those constitutional promises into practice.
It absolutely is. It's worth mentioning there was a concurring opinion from Justice Nkobo. He agreed with the final order, but he strongly argued for developing customary law itself rather than just applying the Intestate Succession Act. His view was that properly developed customary law could perhaps better preserve family units and accommodate unique cultural circumstances. But even he agreed that for the specific families in the Bhe and Bhe cases, applying the modified act was the most fair, just, and equitable solution right then. It just highlights that constant, careful balancing act the judiciary faces. How do you respect cultural diversity while firmly upholding universal constitutional rights?
Yeah, that tension is clear. This deep dive really shows how a country can use its legal system to confront its past, pushing hard for a future where equality before the law isn't just a nice phrase, but a lived reality for all its people. This ruling didn't just change who gets the house or the farm, it powerfully affirmed the dignity and worth of every single individual, irrespective of their race, their gender, or the circumstances of their birth.
And it leaves us with a really compelling thought, I think. How do legal systems everywhere continue to adapt to changing societal norms? How do we ensure that the most vulnerable people are always protected while still finding ways to acknowledge the richness and value of diverse cultural practices? This case is just a powerful example of that ongoing, complex challenge.
Definitely something for you to mull over. Thank you for joining us on this deep dive.